Hey, everybody, welcome back to the next episode of Freedom Under Fire with FPC. My friend Cody Wisniewski with Firearms Policy Coalition's Action Foundation is with us, and he's going to give us an update on everything he can that has happened since the last time he was here about a month ago. If you're new here, we are going to be doing this every month. We have some of the leaders of the groups that we should all be members of, and I want them to bring what they're doing right to you so that you know what these groups are doing and how you can support them. And I'll always have links down below where you can join FPC and donate to FPC and the Action Foundation as well. And don't forget, it's brought to us by Blackout Coffee, who makes the FPC FPC Patriot Roast. And no question that we are donating $2 for every single item, every bag, every box of K-Cups right back to FPC to sue the government. And that comes even during this tariff time we're under, where our cost of coffee has tripled in 30 days. But we're still doing our part to help the fight. So, Cody, thank you so much for being here, man. I know that you are insanely busy with everything that's going on, especially with, the fight never ends. We'll put it that way, right? The fight never ends, no matter who's the head of the country or the executive. And I thank you for your time, man. Thanks for being here.
Yeah, absolutely. Thanks for having me. It's my pleasure.
So what can we inform the populace who are, drooling at what is FPC doing for us right now? What can you give us an update on?
Yeah, I think last time we talked a little bit about the 18 to 20 stuff. And so there's been more. There have been more developments there. It's an interesting area that there wasn't a whole lot of movement on years ago, and now it seems like it's one of kind of the foremost fights in the Second Amendment space, in the gun rights space. So really big there. We talked about the Worth case, which is coming out of Minnesota, which is a flat ban on 18 to 20-year-olds being able to bear arms, apply for and receive permits. So it's interesting there. So we won at the Eighth Circuit, which was a huge win. Minnesota has asked that the Supreme Court take the case. They filed it's called a petition for writ of certiorari. Of course, the Supreme Court decides what cases it takes and which it doesn't. Anytime the government asks, it's more likely that the court will take the case than if it's public interest litigants or private individuals. Take with that what you will, whether or not that's appropriate or not, but it's the truth. So, anytime you win at the circuit level, it makes it more likely the Supreme Court's going to take the case. The other thing that makes it more likely is when the parties agree that the court should take the case. And so we actually just filed our response to that cert petition, and have basically told the Supreme Court, you know what? We actually agree that you guys should take this case. We agree that this is a massive issue. And now there's a split on this. There's courts that have come out on the other side saying that 18 to 20-year-olds are not part of the people for the purposes of the Second Amendment, which is wild. And so basically we agreed that the court should take the case, but of course, we maintain that we were correct and that the Eighth Circuit ruled correctly, and that the Supreme Court should take the case to not just affirm our victory there, but also to make it clear nationwide that 18 to 20-year-olds have a constitutionally protected right to keep and bear arms.
Yeah.
And it's in a really interesting posture now because, we last talked about the win in Lara, which is the case in Pennsylvania. Pennsylvania asked for an en banc review of the circuit, meaning that the full circuit would sit and hear the case. Right. Well, that was denied. We also have the NRA v. Bondi case, right? That's not one of ours, obviously, by the name. But, there was just a decision in that case upholding Florida's law. So now there's this interesting posture on these 18 to 20 cases. And then, of course, there's the Reese case, which we talked about last time as well, which is the challenge to the purchase ban for the federal purchase ban for 18 to 20-year-olds. They had asked for an extension on their en banc deadline. Again, asking for the full circuit to review the case. Their deadline was technically Monday. The court did not rule on their extension motion. So, yeah. And again, that's the federal government, right? This isn't an individual state.
Right.
Technically, you don't have to file a petition for rehearing en banc. It's not a requirement. And their deadline for asking the Supreme Court to review the case would be sometime around the end of April. So it's not that just by not filing that the case is over. It also doesn't necessarily mean that they realize the deadline passed. Maybe, I don't know. Maybe they are just going to rely on an ungranted motion for an extension. Who knows?
Yeah. They're all calling the judge's chambers. Hey, judge, buddy, pal.
Yeah. But it's this really interesting posture now where you've got several wins on the 18 to 20 space. There's a couple circuits that are dissenting, but they're by far in the minority. But now there's a case that's directly squared up for the Supreme Court to potentially hear and review on this issue and weigh in. So I think that we talk about this issue area, or at least we've talked about this issue area a lot in the past few months, even the past year. But it's because we've been really uniformly successful in it, and it really presents a really important question for the court, and it's a really good posture for the court to kind of take this case and weigh in on the issue area.
Yeah, I agree. Especially when you look at the post-Bruin world and the tests that the government has to actually undertake to see if something was consistent with the nation's historical tradition of firearms regulation at the time of the founding and 1791. It's going to be hard for any government official to say that things like the Militia Act didn't exist, because these members were required to be part of the people and to be armed as part of the defense of their communities. So it's good I can't wait to see where this goes, because I think it's all coming to a head at the right time, especially with the current makeup of the court that we have now, the Supreme Court. And as a side note for people who were listening, although it wasn't Cody's case, the one he brought up in Florida, Pam Bondi, our current attorney general, was defending Florida's unconstitutional laws on 18 to 20 year olds. I just want to throw that out there, in the interest of being fair. What else do you got there on what you guys have been up to since we last met?
So I got another really actually kind of interesting one. So we have a case in DC challenging DC's magazine restrictions. The case is called Ware DeRoca versus DC. And here's where it's really interesting. And here's where it's the kind of like unsexy cases that you don't hear about very often, or the issues that you don't hear about very often, that really impact things. So DC has a precedent that basically says that you cannot bring a pre-enforcement challenge in the District of Columbia on Second Amendment cases. And I'll break that down. Basically, if you look at the vast majority of cases that are brought by, us, by any other, Second Amendment group, any other public interest group in litigation, like whether they're doing speech or religion or privacy, it doesn't really matter. Generally speaking, they're all pre-enforcement challenges. Right. What that means is there is the individual plaintiff in the case says that they and would engage in a certain course of conduct, but for a law that would expose them to liability. So an example of this would be, somewhere has a magazine ban. I would purchase and have concrete plans to purchase magazines that accept more than 10 rounds, but for the ban, which both prohibits me from doing so, and if I were to do so, I would be exposed to criminal liability, right? A lot of places, this is a felony, fines, imprisonment, several years in some cases. And so that posture is basically saying, look, and it can't just be like completely attenuated, right? These are people who, in this case, right, own firearms that do accept magazines that could, accept more than 10 rounds, but are prohibited from doing so in the place. Like a common, I was going to say like a SIG P320 owner in California, but that's unveiling a whole other set of news. A Glock owner in California, right? They have a firearm that can accept those magazines. They would acquire those magazines, but for the law. That's what a pre-enforcement challenge is. In the other context, like in speech, there's a law that prohibits you from speaking, saying a certain thing, or speaking in a certain area, right? Well, my hypothetical plaintiff in this case often does demonstrations, would speak in that area, or would say those things, but for this law.
Right. Pre-enforcement challenge.
The reason you do that, the reason why those are important, is because it shows that there is some people that are actually harmed by the law, that are changing their conduct because of the law. but it doesn't require those people to expose themselves to actual criminal liability, right? You're not required to engage in illegal conduct to challenge the law.
Right.
If that was the case, we would be in a place where you could never challenge any of these laws unless you were actually charged with a violation, which is hugely problematic, right? Like people tend to be risk averse. People don't want to violate the law. Of course, I would never tell my clients to violate the law. And so these pre-enforcement challenges are really important. Well, in DC, they're impossible under precedent. You have to have either actually be prosecuted. You have to have been specifically threatened with prosecution, which, of course, knowing this, why would anybody ever do that, right? Then they would expose themselves to lawsuits. Or you have to have like a specific denial for something. Now, the first two are obviously problematic for the reasons we've talked about.
Right.
The reason why the denial is problematic is twofold. One, it's stupid. Like, so-called assault weapons are banned in DC. Why? Like, what is the purpose of applying for a permit? You literally cannot get it. It cannot be issued. It is illegal. So it's stupid. All it does is serve as a bar for people from being able to vindicate their rights. The other side part of that is, what about magazines? You can't permit magazines. They're not registered in DC. It's a flat prohibition. You can't bring them into the district. And so it puts you in this weird spot. So we have a lawsuit that challenges the magazine case, that challenges the magazine ban. DC filed a motion to dismiss, basically saying, hey, look, these guys don't meet the standing requirements that have been established by the DC Circuit. We responded. We went, yep, you're right. But your standing requirements are stupid. So DC is the only circuit that does this, right? Every other circuit, you could have pre-enforcement challenges. You can look at our challenges, see that they span the country, and know that we're doing this this is the case everywhere. And it's not just us, right? Like ACLU uses pre-enforcement challenges.
Right.
So everybody does this.
Everybody does, yeah.
And so, like, not only is it only DC only does it for the Second Amendment.
Yeah, right.
Not apply this same bar for First Amendment challenges or for Fourth Amendment challenges. So it is not just an outlier circuit. It is also completely discriminatory against Second Amendment protected rights. So we looked at this and we went, you know what? This is our opportunity to really dig in on this issue. And it's a little niche. It takes, 5 minutes to explain, which is not, normal of a lot of cases, but it's really important. Standing is something that is weaponized by all governments. I don't care what letter comes after their name. Standing is weaponized by all governments to keep people out of courts, whether you see it in Second Amendment spaces in what you would assume would be friendly jurisdictions who just don't want to go into court and don't want to have to, defend a certain law. Or if it's, California trying to push back against against coastal zoning laws. Like, you see it everywhere. If you ever interact with a public interest attorney, standing is a swear word. We're used to fighting it regularly. So it's one of those things where, it's probably not going to make headlines unless something big happens, right? It's going to take some time, right? These things courts are slow. We could talk about stays and delays with our former Florida AG, which is probably an important topic, but courts are slow. And so it's something that is not going to attract much attention, but is a really important fight. It's a bar to entry to the court first and foremost. And they're making everybody jump through ridiculous, futile hoops. And it's offensive. And so it's one of those cases where, it's not going to, like I said, not going to make headlines, probably not going to be on Fox News. But it is really important into the broader fight of making sure that people have access to the courts, and also that there's access available for any future infringements. Anything that the district does in the future, right, is available for challenge as necessary and needed.
Do you know what judge you drew on that one yet?
Oh, I do. That's a good question. Let me pull that up for you.
Not that there are many favorable ones in that circuit, but
Yeah, DC is really interesting. DC's odd because you always have standing. Apparently, we're just going to talk about standing today. You have standing to file a lawsuit in the district in which an injury occurred. But for the federal government, you also have standing to sue where the agency is located or where the government actor is located. And so DC became this place for an extended number of lawsuits because so many federal agencies are based there. Right. Some people found out during COVID that the CDC is not, but most federal agencies are actually based in DC, unsurprisingly. And so it's become this place for a lot of lawsuits. And it's also, the DC circuit is called the mini Supreme Court because there's so many cases that go up in DC because of this. There's so many suits against the federal government. And because the Supreme Court only takes 60 to 70 cases a year, if you get a circuit decision, that could be your final stop. And so for a lot of people, the DC circuit became the mini Supreme Court, and it's not the most freedom interested circuit in the country.
Let me ask you this one related to the Supreme Court. I'm sorry?
Judge Contreras.
Okay. Regarding the Supreme Court only taking 60 or so cases a year, where they used to take 200 plus, do you see a way that we can, obviously this is just you and I spitballing here, like is there a way we can get them back to actually doing their job a little more often?
So this is a super loaded question. The problem is we care too much about Supreme Court opinions now.
Yeah.
The federal government does too much. All governments do too much, which means there's more things that are the subject of higher stakes lawsuits. And as a result, there are so many more things that are just going on through the court system. And they've all become interrelated. Not directly in all cases, right? Like an Armed Career Criminal Act case isn't necessarily going to impact an EPA case, but because precedent has become so pervasive and so relied upon, opinions have also gotten significantly longer, right? Like if you look at average opinion length, that has also increased as the number of cases that they've taken has decreased.
Right.
The problem is because this is all interrelated, you have to unwind the wheel. And so the end day, right? The problem is that the federal government does too much. And so we need too many cases to go up to get opinions out of the Supreme Court. And they're too worried about how their opinions are going to impact other spaces. And so those opinions have become longer. I don't think that there's a way to get the court to grant more cases without unwinding one of those other wheels.
Yeah.
And that's the significant problem. I mean, I do think one way to kind of solve some of this logjam and some of this problem is to fix some of the circuits again, right? So the Fifth Circuit split into the Fifth and the 11th back in the 80s.
Yeah,
I'm guessing. I think it was 86. I could be wrong. The Ninth is too big, right? The Ninth is the biggest circuit. The Ninth is the only circuit that can't sit. The Ninth has never sat fully en banc. It has when you go en banc in every other circuit, you get the full slew of judges, that are active in that circuit. The Ninth, you get 11. So you do another draw. There is technically a procedure for the Ninth Circuit to sit fully en banc. I don't believe it has ever happened before. I don't even think that they have a courtroom big enough.
I don't
actually,
think so.
because it's like 29.
Yeah, there's a lot of them. Yeah.
The Ninth is too big. You need to split the Ninth. And it would also more accurately reflect some geographical breakups if you did it I've always said you should do the coast in Hawaii and you should do inland in Alaska for the Ninth Circuit, but that would help, right? It would decrease the load on some of the circuit issues, which could potentially help. But yeah, without unwinding federal programs, you're never going to get to the point where there's more availability for the court.
Yeah, maybe we can get Elon to help us out.
Well, half the cases they take are criminal.
Yeah.
Right. So they're going to grant, let's say they grant 70, 35 are criminal cases.
Right.
Now you're down to 35 per term of, potential high impact civil litigation. Half of those might be boring. Right.
Yeah. Well, probably 2/3 of them.
Probably 2/3 of them. Right. Sometimes they're really niche microscopic issues. And so it is a huge problem. But I don't think that you can fix that without unwinding other things.
Yeah, unfortunate. All right, what else has FPC been up to here behind the scenes?
Well, very loudly, one that you'll be happy about, the Granada case, which is challenging Massachusetts handgun roster.
Yeah, buddy, I'm heading up there next month to speak about it.
Awesome. That one is going to have motion for summary judgment hearings coming up in that case. So posture-wise, right, motion for summary judgment when you're talking about our kind of cases, pre-enforcement challenges where the facts are very straightforward. Most cases are decided on a summary judgment basis. That basically just means that there's not facts in dispute, and so you don't need a court to do the fact finding at trial. You're just resolving issues of law. So that's a big one. That's been around for a long time. So it's good to have that teed up and to be able to kind of get into court and really kind of make the final arguments there so that we can hopefully get that thing struck down and then move through the appellate process. That always happens in cases like this, but that is one that is, that's a huge one. I think those handgun rosters, people who don't live in roster states don't know what it's like.
Yeah.
And just don't realize how pervasive they are, right? It's just a ban, right? It's a ban on handguns. And they're just picking winners and losers in terms of the handguns that you get to use. So those types of issues are really important. And that's a case that's been pending, like I said, for a really long time. So it's good to see that one get teed up. Massachusetts obviously hasn't slowed down. I know that, I know you covered the Escher case, which is our challenge to the 18 to 20, the new 18 to 20 law up in Massachusetts, where everybody got a piece of the action. We pulled together the full coalition of, or at least a lot of groups together on that one to work together. So Massachusetts always has issues, but this Granada case is one that it'll be nice to finally see teed up and to really see it go in and be able to dig in on the problems with the roster there.
Yeah, it'll be sweet. For people who don't live there, it's tough to understand what we're talking about. But just a quick to surmise what the Massachusetts does. The governor now, who was the attorney general, there's basically an attorney general list of what they think is safe and related to firearms to be sold within the state. So they're saying, in just to surmise it, that a Glock Gen 3 is safer than a Glock Gen 4 or Gen 5, where they've made improvements to the firearm. So you can't buy a Gen 4 or Gen 5 in Massachusetts because the older versions are safer. It's just ridiculous what they're using. It's just a blanket ban of way to stop new guns from being sold in the state. And I can't wait until that goes down in flames, and hopefully I'll be there for it. But I remember begging the powers that be at FPC to take up that case, and I'm so glad that they did. And I helped, with the, getting some people to sit as plaintiffs and stuff like that. So it's a case I can't wait to see all the way through, because I'm invested in it, not just with my efforts, but emotionally. I hate Massachusetts with a passion as far as the gun laws. So I can't wait till y'all destroy them. Yeah,
and that's a case. So that's a good kind of intro or continued intro into the delays thing. I mean, that case is going on 4 years old now.
Yeah.
That case was filed in June of 2021.
Yep. Well, COVID, COVID.
Yeah. And so it's, at first it was a motion to dismiss, and then the case was remanded back, and now it's on summary judgment. And, now there's still an appellate process ahead. Mm-hmm. In cases, in public interest cases, the appellate process is almost guaranteed.
Yeah.
Because when we win, the government is going to try and defend its law. They're not guaranteed necessarily to seek Supreme Court review, but they're almost always guaranteed to go up to the circuit. Now, there are situations in which where that doesn't happen, and we get a district court win and the government backs down, but it's very rare. So when you've got a case that's 4 years old at the district court, the summary judgment still has to be argued.
Right.
And then the court has to issue its opinion. And then you're talking about the appellate process. And so it's some of these ones, take a really long time and a lot of investment and a lot of work just to get them to the point where it should be rather straightforward of, X law is unconstitutional and we're good to go. But 4 years later, and we don't have that yet. So
right.
But nice to have it soon.
Being the First Circuit, and they're known for things taking forever and going all the way to the 99th yard line before they let something go. So again, thank you all for your continued pressure there. It's greatly appreciated by the people behind enemy lines.
Yeah, absolutely. I mean, it's it's a multifaceted fight. We're sitting right at 60 plus active cases. And so it's tough. You've got to be able to do everything that you can to focus everywhere you can. You got to be able to focus on specific issues, on specific kind of pillars, on our focuses, which are on the website. You can see what we focus on. And then you've got stuff that pops up too, right? And sometimes it's discrete issues, sometimes it's bigger, right? It's not always, Snope, right?
Yeah, right.
It's not always the big, so-called assault weapons ban. One of the other things that we're briefing right now is our challenge to the Illinois public transportation ban. Mm-hmm. Right. And there's things like that come up, and that's a really important issue. If you ban carry on public transit, you prohibit anybody from carrying at any point in their day if they use public transit.
Right.
So it sounds small, but it's really this massive impact on carry, right? Anybody that relies on the bus no longer can exercise their right to bear arms. So you deal with these, you have to deal with this balance, and there's lots of people who are behind enemy lines. I have admitted to being Californian in public already, so it's already on the record. But I watched my dad go through it when I was in law school, before I was even in this space, watching my dad try and jump through the hurdles in the loops of being a gun owner in California and the problems that it causes. So it's tough in a lot of these places. So sometimes it's important to be able to, it is important to be able to bring the big, massive assault weapons ban case. It's also important to be able to bring the, public transportation ban case that really impacts people who are using that in their day-to-day life. And sometimes you got to file in Massachusetts or Illinois, and other times you got to file in Texas. It just kind of depends on the day.
Right. Considering the government uses the death by 1,000 cuts against us, sometimes you have to use it against them to get an effective victory that'll, be long lasting. Because, they'll try to always reform whatever ban they had whenever they, in theory, lose at a high court, just like a la New York. And speaking of the subway system there, I just saw this morning when I woke up that the Trump administration has been giving federal funds to their transit system. And part of their agreement was they had to keep the system safe. So Trump's people today said, well, if people are getting mugged, shot, killed, and set afire, then you're not keeping it safe. We're going to pull funding from you. So I don't know if Illinois does that, but that might be something you can use in your argument. Like, if, they're getting federal funding to keep it safe and they can't keep it safe. So
I bet everything's federally funded these days, as far as
especially transit. It's a tough business to keep profitable in any way.
Yeah, absolutely.
Well, dude, that's been quite a few updates here. We're 29 minutes into it. Do you have anything else for the folks?
That's all I have for specific case updates. But I did think, one thing that's really interesting that I know you've been talking about a bunch, and that has been really kind of the topic is the new AG and these federal positions and cases. And one thing that's big is this delay in these stays. And it's really interesting. It's kind of a perpetual balance, because courts are really deferential to the federal government, and courts are generally pretty likely to grant stays, at least what the court would determine to be a reasonable one. And so you get into this weird position where, in some cases you had the AG's office coming in and asking for 60 days or asking for open-ended stays. Now, those are really dangerous.
Yeah.
Open-ended. I once worked on a case that was on I think we might have talked about this before, that was on open-ended stays for 21 years. And it was like a 3-month or status report every 3 months. And the status report was just like, nothing's happened yet. Like every 3 months for 21 years. Open-ended stays are very dangerous. I don't care if you think that the person on the other side of the V is favorable to your position or not. Time goes by, administrations change, appointees change. Those are dangerous.
Right.
Lengthy delays also get dangerous, right? You're talking about like this potential for, okay, how long do we have to resolve this case? Look at the Granada case, right? 4 years and it's still in the district court. So lengthy stays can also be dangerous. At the same time, if opposing counsel is going to, if they're going to change position and advocate for, the actual original public meaning of the Second Amendment, you want to give them the opportunity to do so. So it is this really interesting balance. I know a lot of people have had a lot of questions and a lot of it's come up on, perpetual stays, 60-day stays, 30-day stays, extensions, those sorts of things. This is one of the first times in my career that people have been paying attention to extensions.
Yeah.
Like attorneys will ask for extensions as a matter of course. Sometimes it's somewhat frustrating. Courts will grant them as a matter of course sometimes, but we were pretty successful in keeping those things mitigated in our cases and not getting open-ended stays, getting much shorter extensions and stays. And so I think that's really important. But I think there's a lot of pressure right now on the AG's office. There's a lot of pressure for them to, review and hopefully fix some of the defects that existed in their prior positions, which I would argue were not very constitutional in most of their iterations. And there are a ton of cases that there are out there that impacts. And so, while that might mean that it's more work for them to fix these issues, that's kind of what they're there for. So it is really interesting to see, but we're really kind of coming to a clock here. And I think that's really important. We're getting to a point where we're going to start to expect some corrections, some updates, some filings, and those sorts of things rolling through. And I'd imagine that's going to happen. When it happens, it's going to happen quickly.
Yeah, well, we hope. Yeah.
So there's a lot of similar cases across the country on similar issues. And so it's not as if they have to form 100 different opinions. It's really just a few that need to get applied throughout. And there's really only one opinion that it's very easy. All you got to do is respect the original public meaning of the Second Amendment, understand that it protects a pre-existing natural right, and stop trampling all over it.
Yeah,
and then it's really easy to apply that in all of the cases. I'm happy to pre-write some points for them if they think it would be helpful. I can guide them, no problem, more than willing to do so. But I think once that shoe drops, you're going to see it across a lot of cases rather quickly. So, I'm hopeful that we'll get that soon. I think I think her second deadline's coming up.
Second deadline just passed Sunday.
Oh, cool. Awesome. That one just flew right by also. So that's cool.
Yeah.
So yeah. A lot of these stays that were asked for were 30 and 60 days, starting in February, was that executive order. So those stays are going to start expiring. Status reports are going to start being due. And people are going to start pushing them, right? I mean, you've had a month, you've had 2 months, articulate your position, or let the case go forward.
Right.
Just, look, you can. The government has a lot of options before it, and it doesn't have to fight these. But also, we're not in court because, we want a fancy memo at the end of the day that says well, we may think that they're right, and so no, we're in court because we have very good cases that we are confident will win or should win, at least as long as the court applies the text as informed by history test that was established in Heller and reiterated in Bruin.
Right. So
I'm very happy to get court opinions, and we've demonstrated that we've been very successful. I mean, we had 26 victories last year.
Yeah.
So it's happy to be in court if that's the right place, but also like I'm really looking forward to seeing their position one way or another, and that way we know what to expect over the next few months.
Yeah, guys and gals, you've heard Cody talk about it. They have many cases. We love when they sue the government. Everybody loves when Jared does a video that FPC is suing for this. They need us, the membership, to help, because we are the lifeblood. Donate if you are a member. Donate more if you're not a member. Cody, where can they go to join and donate? Let's give them all the information.
Yeah, absolutely. So you can go to joinfpc.org, or you could just go to firearmspolicy.org. There you can learn everything that you need to know about Firearms Policy Coalition. You can see all of the casework under a tab called Our Work. You can also see the mission and see the pillars of focus on the About page. So that's a perfect way to go join the organization. You can also, of course, donate, as you mentioned. And then also, I'm at FPC Action Foundation. We're at fpcactionfoundation.org. We're a 501c3, so you can go ahead and donate to support the fight that way too, if that makes more sense for you. But what's really important is just that people are getting involved, and that people are part of the fight. People are talking about the work, people are sharing the work, and supporting when they can, and kind of partnering with us on these lawsuits. So that is hugely important. We appreciate everybody that makes these lawsuits possible. And we also, really appreciate you giving us a platform to talk about them and talking about the work, and always extolling the virtues of becoming a member.
Yeah, man, it's huge, guys and gals. Like, skip a pizza and join FPC. It's literally, I think pizzas cost more than a membership does now. So
I might steal that.
Same team, man, same dream. Guys and gals, seriously, join these groups. If you love it when they fight for us, and they can't fight for us unless they can fight for us. So let's join, let's donate. I know it's a tough time right now, but $5 helps, $10 helps. And again, skip that pizza this month and join FPC. And I'll have the links down below as well, so I'll make it easy for you. You can just click the link, join, donate. And Cody, again, thank you so much for your time, man. I know you're burning the candle at both ends, so I am grateful for your time.
Absolutely. Thank you for having me. Really appreciate it.
My pleasure. Thank you all for joining us on this episode of Freedom Under Fire. Again, he'll be here in 4 more weeks with another update. This is going to be an ongoing series. Join us by helping them by buying some Blackout coffee. Not only is it the best coffee in the world, the freshest, we ship it to you within 2 to 3 days of roasting, but you can actually help FPC's mission in suing the jackbooted thugs. Guys and gals, appreciate y'all. Subscribe to the channel down below. Forward this to everybody you love so they know what FPC is doing. And I'll see you on the next one. Take care.